What are two things you should never do during your deposition in a medical malpractice case in New York? Would you like to learn the answer? Come join me for a walk on the beach as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, in case you don't know, a deposition is a question and answer session that's given under oath and takes place in our office, in our conference room. It's pretrial testimony, it's sworn testimony, where you swear to tell the truth. Now, there's no judge there, there's no jury there, but there is a court reporter, a court stenographer there to record all of the questions that the defense lawyer will ask you and all of the answers that you give. And that carries the same exact weight as if you are testifying at the time of trial. Okay, so what are two things you should never, ever do during a deposition? Number one, you should never, ever lie. Now, you think that's simple, right? Actually, it's not. Because there may be instances where you say to yourself, you know what? This guy doesn't really need to know the answer to that question. I'm not going to share with him the details, the real details of what occurred. And I'll give you an example. Let's say you were convicted of a crime many years ago. And now the defense lawyer asks a question and says, hey, Mr. Jones, were you ever convicted of a crime? And you're thinking to yourself, he's never going to find out. I'm going to say no. Well, guess what? You have now destroyed your credibility. Not at that moment, but down the road, absolutely. Why? Because the defense lawyer is definitely going to learn the real truth about whether you convicted. He's going to do a background search. And then he's going to spring this and ambush you at the time of trial. So that is one thing you never, ever do. And there are strategies on how to deal with that. What's the second thing you should never do? The second thing you should never do is get into verbal altercations, verbal arguments with the defense lawyer. That's not your job. Your job at the deposition is to answer the specific questions that the defense lawyer is asking you. That's why you're there. You're there to give him factual information about what you remember happening and what injuries you suffered as a result of the wrongdoing. It is never going to help you to get into arguments with the defense attorney to argue over the questions that are being asked. Why are you asking me that question? That's ridiculous. Or I don't have to answer the question about how much money I was earning. Or I'm not going to answer questions about how many times I have sex with my spouse. Are you nuts? All of those questions may actually be appropriate. And that's one of the reasons why your attorney is there, to make sure that the questions you are asked, in fact, are appropriate. And if they're not, now he's going to pipe up and say something. So, what are the two things you should never do during the course of a deposition? The first is never lie. The second is never get into verbal arguments with the defense lawyer. It certainly will not help your case. Let your attorney do the verbal jousting with the defense lawyer. You're there to answer questions. Want more information about how these types of cases work and your matter happened in New York? Then I invite you to pick up the phone and call me. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.